1969 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာ80 Civil Revision before ဦးကျော်ဇံဦး and ဦးသက်ဖေ judges TP Mamonti applicant versus မတ်သိန်းလှိုင် Alliance မတ်အစရာ respondent ဤစီရင်ထုံး audio book ကိုထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးမိသားစုကစီစဉ်သည် suits for rendition of accounts and for dissolution of the partnership and for recovery of the share of the assets and profits, whether Article 106 or Article 120 of the Limitation Act is applicable. Hell, the respondent plaintiff claim not only for the rendition of accounts and for dissolution of the partnership, but also for her share of the assets and profits. However, the partnership was dissolved on 22nd February 1962 when the respondent's husband died. The suit is therefore governed by Article 106 of the Limitation Act. Tan Soo Lee versus Yoon Tong Ho, 1958 BLR 365 HC distinguished. Mr. M.A. Sephan for the applicant, U Line for the respondent, U Jozan U judge. The application to revise the order of the Registrar of the City Civil Code, Yangon, dated 28 October 1968 must be allowed. On 9 October 1967, the respondent applied for leave to sue the applicant, a foreigner, for accounts and for dissolution of partnership and for injunction, as a pauper alleging that her husband entered into partnership by a registered deed of partnership dated 20 December 1957, a copy of which has been attached to the plain with the applicant to run the business known as TKA Bakery and Confectionery in 40th Street, Rangoon, and to share the profit and loss equally, but died in Yangon on 22nd February 1962. It was also alleged that under Clause 13, 14, and 15 of the deed, the firm was to be wound up upon the death of a partner, and all sums due to the deceased were to be paid to his heirs and legal representatives, but the applicant, who is the surviving partner, failed to do so. The applicant, in his objection dated 7th May 1968, states that the respondent has no cause of action and the suit is barred and not maintainable, adding that she, not being the sole heir of her husband, has no right to sue in her sole name. The arguments on the questions of limitation were heard, and the registrar, relying upon Tan Soo Lee versus Yoon Tong Ho, held that since the suit is for accounts and for dissolution of partnership, Article 120 of the Limitation Act applies and the suit is not barred as it was filed within 6 years of the death of the respondent's husband and overruled the objection, hence the application. The registrar has failed to see the point. In the authority relied upon partnership was still subsisting and there was failure to render accounts. In the present case, however, the partnership was already dissolved on 22nd February 1962. When the respondent's husband died, the partnership was at will, and though there is no express provision in the deed that the partnership is dissolved upon the death of a partner, it may be inferred from the provisions of clause 13, 14, and 15 of the deed that the partnership came to an end upon the death of the respondent's husband, for they gave option to the surviving partner to purchase the share of the deceased partner and to take accounts and pay whatever is due to his legal representatives. Whatever it may be, Section 42 of the Partnership Act says, subject to contract between the partners, a firm is dissolved, c. by the death of a partner. This section relates to events whose occurrence will dissolve the firm if there is no agreement to the contrary. On the death of a partner, the partnership is at an end. If, however, it is continued, it may amount to a new partnership. It may not be out of place to mention that the respondent in paragraph 10A of her plaint also claims not only for rendition of accounts and for dissolution of the partnership, but also for her share of the assets and profits, since the partnership was dissolved on 22nd February 1962 on the death of the respondent's husband. The suit is governed by Article 106 of the Limitation Act. The authority quoted by the registrar also says that if the suit for accounts is brought after the dissolution, then the period of limitation for such a suit is 3 years under Article 106 of the Limitation Act from the date of dissolution, i.e., 22nd February 1962. In the instant case, the suit having been filed more than 3 years on 9 November 1967, it is clearly barred. Article 106 covers a suit for partnership account and to recover the plaintiff's share of the assets and property of the partnership business. The residuary Article 120 applies only to a suit for dissolution of an existing partnership and for accounts. The suit was clearly misconceived by the registrar. In the Punjab case, relied upon by the advocate for the respondent, the surviving partner carried on the business alone, and to the suit for dissolution and accounts, he pleaded that the firm had automatically been dissolved upon the death of his partner. It was held the suit came under Section 37 of the Partnership Act, which says that when the surviving partner continues the business without the final settlement of accounts, the representative of the deceased partner is entitled to such share of the profits made after dissolution or death, and the prayers in the suit for dissolution was an error. It was also held that Article 106 applied to accounting up to dissolution on death of the partner, and there was no question of applying the Limitation Act to the accounting period subsequent to dissolution on death, as the course of action continued from day to day. It will be seen that in the present case, there is a claim for a share of the profits on the death of the deceased partner or on the dissolution of the partnership, and therefore Article 106 applies. The plaint makes it clear that it is a suit in respect of a dissolved partnership. This is not a case of the respondent become a partner in the new partnership, as the agreement is silent on the point, but claiming a right to a share of the profits of a dissolved partnership as a legal representative of the deceased partner. Under Order 33, Rule 3C of the Civil Procedure Code, subject to the jurisdiction of the court, to allow amendments to be made, the court shall reject the application for leave to sue as a pauper where the claim appears to be barred. In the circumstances, we set aside the order of the registrar above referred to with cause. Advocates' fees 51 Jet.